I'm going to go ahead and introduce our speaker for today because she has a lot of information. And Julie Rivers is a seasoned lawyer who practices family law and estate planning and probate and all of those litigation settlement and consultations that surround those subjects. She is a frequent lecturer to lawyers and laypersons alike on the topics of estate planning and probate. She has been a TAN member for 7 years, and I believe last year you were the president of the Santa Fe Estate Planning Council.
Yeah, the last 2 years. With
okay.
Very, very much her help.
And so what happens when you just discovered that you're appointed a trustee, a personal representative, an executor, or power of attorney? Yikes. Something we've never been taught to do, and yet some poor soul thought you should serve as in a fiduciary capacity. I have 2 people who have asked me to do that, and I'm still contemplating. Now what? Julie will take we'll take you through what it means to be a fiduciary and how best to navigate what can be treacherous waters. And so take it away, Julie.
So while I am, let's see, I'm co-hosting, so I can do a share screen. And let me get this up so I can get it where it's supposed to be, which is not there. Let's see, from the beginning. There we go. So you were sent a ton of material because, of course, this is a topic that goes deep. And I was trying to think, okay, what do I want to cover? You know, do I want to do red flags about financial abuse of the elderly? And I thought, well, let's just include, you know, information so that they have information. So you'll see that there is an APS sheet. I also downloaded some stuff concerning that from AARP. I have a memorandum for what to do when someone dies, because nobody tells us about that either. And that's not really, you know, sometimes you just have to step in and it's like, what am I supposed to do? So I've given you kind of a memorandum about how that works. And then there's a software program I use called Wealth Counsel. And I liked what they had to say about counseling trustees on their fiduciary duties. And so I went ahead and included that along with the memorandum I give my clients concerning trustees' duties and responsibilities. And then also kind of a breakdown of the personal representative, which is what New Mexico calls the executor, which is what it's called a lot of places. And the PR, the personal representative, what their duties are. And so I've given you some in-depth stuff so that you have resources available to you, because you're not going to remember, you know, a smidgen of what I say in another month. You will have slept since then. So I want to go ahead and give you the data that you need. So let's talk first about what is a fiduciary. And you'll see that it's a relationship founded on trust or confidence. And that could be your bank as a fiduciary. You know, they hold on to your money, you put $10 in there and they're supposed to keep it in there unless you pull it out. And so that would be a fiduciary. But we're going to talk specifically about certain fiduciaries, and I'm going to talk about what those are here in a minute. So I decided I'd kind of go David Letterman. And so I came up with basically 10 things. And this was also this PowerPoint was also provided to you. So the first thing to do is to call your friendly lawyer. And because that can make it a lot simpler and they can help you navigate real quickly what you need to do. You want to avoid conflicts of interest. That sounds like an obvious one, but it happens all the time that somebody will decide, well, I think I'm going to do this. And I'm going, yeah, I don't think so, Skippy. We can't do that unless we get permission from everyone that's involved in the case before you do, you know, buy the house or the car from the estate. Your job is to protect property. And keep in mind, I'm doing a real broad brush about what fiduciaries are required to do, not the specific roles in which you can serve as a fiduciary, which we will talk about in a second. So protecting the property, that's your job. You're kind of like the one standing at the door, the French gendarme, who makes sure, and you also make sure that you know what all the property is. You pay expenses, taxes, insurance, anything to make sure to maintain that property. You're required to use care and prudence. In other words, don't be a dumbass. You're required to make distributions to the beneficiary or on behalf of the principal if you're serving as a power of attorney. You're required to do record keeping. And record keeping doesn't mean, just throwing the money in your account and then using it, and just keeping track of it. It means opening up a separate account that's for the sole purpose of serving as that fiduciary. Making reports is required. There is one role that doesn't require a report. That's the power of attorney. However, financial power of attorney. However, if you don't make a report, and then when the person dies after they've died, because powers of attorney, they work during lifetime. And the minute you die, those no longer are effective. Then the will takes over, or state law if you don't have a will. The trust can work throughout the time that it's, in place. And so one of the events and activating events in a trust would be, of course, if the person who created the trust, who is called the grantor in New Mexico, if that grantor who created the trust dies, then of course, who's the successor trustee? And it'll be in the trust. And that would be an activating event. And that might be when they start doing distributions and that type of thing. And I want to disabuse anybody of the notion, I'm taking a little sideline here, that if you think you're avoiding probate because you've got a trust, think again. That's not true. And when lawyers say that, I want to pull my hair out, because that's not actually a true statement. Also, on top of that, keep in mind that as far as a trust, it can cost as much to administer a trust as it does to do a probate. So don't just think, oh, I have to have a trust. There are certain reasons why you would have a trust, and there are a lot of reasons why you may not. So don't fall for that scam. So compensation is one of the issues, and we'll talk about that. And then, of course, if you are being asked to serve as a fiduciary, and in the pre-talk we had right before we started this talk, a couple of people said, hey, I'm going to be serving as a fiduciary in some capacity. Ask to see the document, even if you aren't serving at that time, but you've been named, so that you have it readily available. And by having it readily available, you can find out where your power is, because you're limited by the document itself as to what you can do. There are things outside of it that you can do, but those are limited. And that goes back to number one, which is when you have to talk to a lawyer. So you have a duty of impartiality, which means that when you're giving money to the beneficiaries, maybe you're doing, or you're having to, you have, a couple and one's in, they're both incapacitated, and you're having to manage their estate for them while they're alive and are unable to themselves. You have to operate impartially. You can't just go, well, I like this beneficiary never bothers me, but this one constantly calls me and it drives me crazy, so I'm going to give this one a little more. You can't do that unless the trust specifically provides for it, or the will. You have a duty of undivided loyalty, which is the no conflict of interest. And you have to, as we talked about earlier, administer that estate or trust with care and prudence. If you have special skills or expertise, if you're a financial advisor, if you serve in some other capacity, you are expected to use it, and you are held to that standard. So know that when you take on that role. So the fiduciaries we're talking about today are the trustee, That person is appointed in accordance with the terms of a trust. A power of attorney, they're appointed, and I'm talking about financial, they're appointed as the power of attorney for the financial piece, and that document is what rules. Sometimes that's on a limited capacity, sometimes it's all across the board. A power of attorney for health, and then you have the personal representative when there's a will, or you'd be called a personal administrator if you're serving in that role. If there is no will, but there's a probate. A probate is filed after someone dies and they have an estate that is worth more than $50,000, or they have an estate that has real property in it, and we need to be able to port that property and make sure the creditors get paid and just kind of wrap up the person's life financially. So let's talk about the incapacity and end of life decisions and kind of talk about what those powers of attorney look like. And we're going to first talk about, I just want you guys to know, because New Mexico is one of the rare states that does this, and this is really a fabulous tool, and it's not well known. But there is such a thing as a mental health power of attorney here in the state of New Mexico, and it takes quite a bit of time to prepare on our side when we're doing it. However, they can really kind of go down in the weeds and decide that, you know, if they're like, say, bipolar, there's certain medications that work, that don't work. We can put a lot of stuff in the mental health power of attorney. So when somebody talks to you and you know they have, they've fought mental health issues throughout their lifetime, you might ask them if they are asking you to serve in a healthcare role or a mental health power of attorney role. They are different. And so let's talk a little bit about the healthcare decisions. And I want to quote, and I'm not going to state it, I can let you all read it, Atul Gawande. And I'm going to talk about him here in a second, but you can go ahead and be reading that while I'm yammering on about these things. So let's talk about the mental health power of attorney and how that's going to work. 1 second, I want to make sure that I don't get ahead of myself. So when about 4 years ago, I had a close friend of mine, professional here in town. She knows I tell this story. A professional here in town in her mid-60s in relatively good health. We're going to call her Debbie. She called me up one Sunday afternoon and she says, I think I need to go to the emergency room. And I said, okay. So I get there in about 20 minutes. And by that time, she's gray, she's shuffling, and she can't put 2 words together. And I don't know anything about medical stuff, but that sounded pretty bad or looked pretty bad to me. We get her there and I start asking her questions about her her healthcare power of attorney. And I said, who's the first person on your list? And she said, oh, she died. I said, who's the second person on your list? Oh, she just got admitted to a dementia ward. Who's third on your list? Oh, she's from South Dakota. And so I said, well, Miss South Dakota, it is until we get you a new healthcare power of attorney. And when we do that, we're going to kind of beef up the language. And then we're also going to make sure that we have somebody here every day, because when you serve in this role, it doesn't mean you have to be at the hospital all the time. But what it does mean is you better be there in the morning when the doctor deigns to arrive and make sure that the things are being taken care of on behalf of the patient. For example, the patient wasn't being bathed. And believe me, Debbie didn't want me to bathe her, and nor did I want to bathe her. And I go down the hallway and I say, nurse, could you please make sure she gets bathed tomorrow? Because she was in ICU for 10 days, then middle ICU for 10 days. She's fine now. And then for almost another 10 days on the regular floor. And so I'm serving as an advocate for her to make sure that she gets bathed. The next day, what am I doing? I'm going in and I'm saying, you didn't bathe her. It's 9:30 at night. What gives? And, you know, I basically badgered them and got them in there to give her a bath. So this is the thing. Those are the roles you serve in. When people say, oh, I want to make sure I have a healthcare power of attorney because I don't want the Terry Schiavo thing to happen, keep in mind that what they're really worried about also is making sure all these little bitty things get taken care of. And so one of the things we had in common, because keep in mind, one of our jobs is to know the personal values of the principal, the person who's the patient, as best as possible to make decisions that she would make, and you stand in her shoes. To be able to do that, we had all read a book. And the name of that book was Being Mortal by Atul Gawande. I would also suggest, and you'll want to write this down because it's not in my materials, that you go to pbs.org, look up there, Frontline Special, and look up Being Mortal. It's about an hour long. About 7 minutes from the end of that video, you will find there several questions that he asks you. Those are that's your launch pad to be able to start unpacking what your values are around your healthcare. If you have been named as a healthcare power of attorney, these are things you're going to want to have the conversation with the person who's appointed you. And so this may be one way to do that, to do an entree in. It's a fabulous hour-long presentation. There's also another document, which I didn't include in the materials because, like I said, I got to get through a lot pretty dang quick. And so one of the other things that's in your materials, that I don't have in your materials, is something called the 5 Wishes. And so just look up 5wishes.org. There is a document there. I'm more than happy to send it to you via email, a draft copy so you can see what it looks like. After doing the Launchpad questions and kind of unpacking those based upon the pbs.org Frontline Special, then you can turn around and use that as a way to be able to go through the 5 Wishes document and go a little deeper. And being able to do that, you can use that as a way to talk with someone who hasn't done that work to say, so are these things you want? What's important to you? Because if I'm going to serve in this role, and if you're not able to express, because they forget, oh, I'm not able to express what my wishes are. And so I'm always having to remind clients, yeah, you won't be able to express what your wishes are. So now is the time to go ahead and be able to do that. So one of the things that you want to make sure when they have a healthcare power of attorney and they've let you know that you're serving, make sure they have a HIPAA release. Debbie's didn't have a HIPAA release with it. That's one reason we redid her document, besides the fact 2 of her people had dropped off. The other reason is when you get that document from them, when you're looking at any of these documents that we're talking about where you're going to serve as a fiduciary, you look to see if there's at least three people, because life gets in the way. Diana could be off in France having big fun, and all of a sudden her friend that's appointed her to serve in a fiduciary role she's not available to do so. And it's usually a crisis. So you want to make sure there's several people in line. So you want to have the HIPAA release so that authorizes them to be able to talk. New Mexico law has kind of a workaround, but it doesn't help you with HIPAA at the federal level. And there's some pretty hefty fines that the healthcare professionals could end up having if they don't follow it. There's also the DNR, and we've heard about the DNR. DNR it's in the New Mexico statutes. There's not anything remarkable about it. If you want more information on it, I'll be glad to send it to you. I give the packet to my clients. It does need to be signed by a healthcare professional, so you sign it in front of one, and that sometimes is something that is used. And I'm going to leave it at that at this point because I want to keep moving. So let's talk about the financial power of attorney. And we have that's called the durable power of attorney. And so that just means it endures beyond the person's incapacity. So one of the things I tell my clients when I'm working with them, and if you know you're going to serve as a financial power of attorney, you're going to want to see if you can gather this information, because if they haven't gathered this information and got it all organized for you, you're going to spend the first week or two doing nothing but just gathering data, going through, figuring out where the accounts are, all this other stuff. So what you want to do is ask them, you want to gather all this information, because one of the things is, if you're serving on behalf of somebody who's deceased or incapacitated, zombie debt is a real thing. The Federal Trade Commission coined this, and that is being able to bring the person's identity to life after they've passed. And by doing that, able to steal data and open up new credit cards and all that type of thing, it becomes a nightmare. So you want to try and get that locked down. And we're going to talk about that here more in a second. One of the things is, I call it the black box. And in the black box, I tell my clients is, so you want to find out, and I use that term so that way we, when I'm working with my clients, we know what we're talking about. You want to find out if they have a safe deposit box. If they have a safe deposit box, where's the key? Are you on the safe deposit box? Because it makes it a lot easier if the fiduciaries are also on the safe deposit box. You have no reason to go into that box unless something's happened. So I usually recommend that they be on the box. Now, on the safe deposit box ownership. One of the other things is, this is the kind of stuff you're going to put in this box. And this is what you're going to ask your person to do if you are being asked to serve as a fiduciary. Please put the last year's tax return. Please put a list of all assets. Please put a list of all liabilities. Include the front sheet of every bank account, credit card, any other type of account that's held, health insurance, life insurance, IRAs, any sort of account that they've got, a copy of the deed to the house, a copy of any sort of operating agreement if there is some sort of business entity. All of the things that we do out in the world, you want to make sure a copy of it's in there so that it can be managed. And one of the things in being able to manage this stuff is, you also want to make sure that all the people who help this person, their names, addresses, phone numbers, email, physical, whatever, are all on there. Is there a neighbor that takes care of stuff that's next door? Then we need to be able to contact that person if you're not boots on the ground, meaning you're local. And so you'll want to make sure that you have all that information too. So you're going to bug this person to say, if you want me to serve in this role, do me a favor. Please make sure we have this stuff. Have them pull their credit report, because by having the credit report, you see on there, there's a Capital One account they haven't used in years and years, but they never closed it. The last thing we want is a zombie debt problem. So you're able to call Capital One and say, close down this account. I'm the power of attorney, or I'm this, or I'm that. You also need to be able to do that so that you know where the bank accounts are. So that kind of gives you a high flying overview of what goes in the black box, but there's something else that goes into the black box as well. Those are the digital assets. We all have them. We're sitting here on this call because we have digital assets. So one of the things that you keep in mind, and you may not be able to see me. I don't know how, whether you can see me or not, but when you look at your phone, you have all these icons. And when you look at your computer, you have all these icons. They all have usernames and passcodes associated with them. Just to get into the actual machine, whether it's a phone or a computer or whatever, those have passcodes. Those need to be in the black box. They need to be updated. The black box goes in the safe deposit box along with an original will. If you don't have an original will, then you don't have a way to probate, because in New Mexico, the original will is sacred. Otherwise, it's presumed that they've destroyed the will. So going back to the digital assets, it's everything from Facebook to your driver's license, to Social Security, to insurance, any of the service portals. So the asset itself is sitting at Bank of America. The portal into the asset, that's the digital asset. Southwest Airlines, any United Airlines, JetBlue, any of the airlines, any loyalty programs, those all are digital assets. Southwest Airlines, by the way, I haven't checked it in the last year or two. They used to port the miles upon death to a beneficiary. If you don't designate it, then of course it doesn't happen, and it may not be allowable to the heirs, just FYI. So you cannot impersonate the user. Back in 2018, we've passed something called RUFADA here in New Mexico, which is basically a Digital Assets Act. And it says, this is how we're going to behave now, people. You can't go ahead and go in, impersonate the user and say, I'm Susie Q, even though you've been authorized to take care of things. There's a problem with the Digital Assets Act. If it's not in the document that appoints you, you're stuck. So it doesn't mean you have access, but you have one more way to get in, and that is the terms of service agreements. You know, those terms of service agreements that none of us ever sign, we just click through, scroll through, hit agree, and move on to whatever we want to do. As an agent, if you're serving in that role and you're having to you're having to manage these digital accounts, guess what? Under the rule, you have a duty to, and I'm going to go back, you have a duty to make sure that you review the terms of service agreement. That's crazy. I know you don't do it for yourself, but now you're being asked to do it for that reason. So let me see if I could go back. Let's see. Yeah. And so we want to make sure that we have those terms of service agreements in place. You can also, through Facebook and through Google, you can go in and you can go ahead and make an appointment. Make sure that if they've made an appointment, it's the same people that are on their power of attorney, because if it's not, then the person who's been appointed under the terms of service agreement or some sort of other user agreement that you might have with Facebook or Google, if they're not the same, then the person who's designated is the only one that can go in. So have your passwords in a safe place like we talked about. Make sure they're in that black box. It can be a purple envelope, but make sure it's in the safe deposit box. So we can use that financial power of attorney for pretty much anything, except you can't have somebody serve who is actually a creditor. The healthcare person, this doesn't cover healthcare. Healthcare is covered through the healthcare power of attorney we just talked about. You can't do voting and management rights of an entity unless that's been appointed through the entity, through an operating agreement that allows for the person to do that. And then, of course, any power that's created by a governmental form, for example, a Social Security. So some people go, oh, well, but I got a trust. I'm helping somebody with the trust. Who needs a power of attorney? You need a power of attorney because there are things that aren't handled in the trust. The only thing that can be done in the trust by a trustee is what the trust holds. That's it. So you can't, if you have a refrigerator and the only thing you keep in it is Coke, you can't pull a Dr. Pepper out of there. So you got to make sure that that container that's the trust, that it has all the stuff in it that's supposed to be in there. For example, this is where a power of attorney would fund the trust. And that means if for some reason the house isn't in the trust, or there's another piece of property that's not in the trust that should be in the trust, then this is where the power of attorney would, because it's outside the trust, be able to say, hey, put this in the trust. That's called funding. They can sign tax returns. They can file lawsuits. Trustees can't do any of that. So if you have co-agents, they can operate independently. That can be kind of dangerous if you guys are operating at different ends. So you want to make sure there's transparent communication. And the last agent standing designates the successor agent unless you have other language in the power of attorney that says differently. And of course, as we talked about, you have reasonable compensation under the circumstances. So what are some of those duties? Well, you have to act in good faith. You act within the scope of the power of attorney. You have loyalty. We've talked about care, competence, and diligence, keeping records, preserving the estate plan, and cooperating with the healthcare power of attorney. And so there are certain duties that require they be very specifically named. These are those duties. And of course, this material, you have all this material at your at your fingertips. So gifting, for example, you can't be doing that unless it provides for that in the financial power of attorney, certain fiduciary powers, and whether you do, also waiver of certain rights. So you've got to make sure that there's specific language that allows for you to do that. Otherwise, the agent has a lot of broad authority. And that's where sometimes you go, well, it doesn't quite say that in the power of attorney. And I remember there were certain things I'm not supposed to do. And if it's not on that list, you may be able to do them. And so you want to make sure you can maintain the principal's standard of living. If they have other persons that are dependent on them, such as a spouse or maybe a disabled child, those things are to be taken into consideration as well. And if you breach your duty as an agent, then you have to restore that value as if the breach hadn't occurred. And then, of course, you get to pay your friendly attorney fees and costs on behalf of the person who had to come after you. So you want to make sure that you, like we talked about, you keep good records. Now, for the most part, this is true. However, I'm going to say something that I don't know whether it will offend or not. Bank of America and Wells Fargo suck. And the reason they suck is because when you're trying to enforce a power of attorney, you nearly always have to go to court to get it enforced because they'll refuse to do it, even though they'll have to pay attorney fees. I have no idea why, but if you're dealing with those, those national banks like that, if you're getting pushback, see a lawyer immediately because you're going to need to do something. Don't waste your time because they do. I've been down that road. You don't want to go down it. And so what they're supposed to do is rely on the power of attorney, and they can't really accept it. So you can, as I say, get court order and attorney fees. They can demand certain types of certification. And it doesn't matter how old the power of attorney is. It can be 25 years old, does not matter. So let's talk about now the person has died. We're not dealing with the powers of attorney anymore. And so these are some of the duties of a personal representative. They're going to send notice to the heirs and beneficiaries. Heirs are those who inherit by law. Beneficiaries are the ones listed in the document. You, again, avoiding conflicts of interest. Are you seeing a pattern here? You marshal the assets. You make sure you got them all. You let the creditors know that somebody died. And by the way, dead men don't have credit scores, so we don't care if these creditors get paid. We do care that we follow the rules. But the thing is, the game is played so that the beneficiaries are the ones who benefit. If the creditors don't file their claim within the statutory time period, they're out. It can be 4 months and 1 day. They're out. They have no way to get their claim paid. And on the ones that you do pay, you can negotiate it down. Then ultimately, you'll do a final accounting saying where the money came from, where you spent the money, and then you ultimately do a distribution to the heirs and beneficiaries. And then again, you've got PR compensation. And we don't know. It depends on so many factors that we look at to determine what that hourly rate might be for a personal representative or a power of attorney or a trustee. And so let's talk about the trustee. And so, of course, you're going to call your lawyer. You can't really navigate trust without using a lawyer. Especially if there are some things that have to be done, it really does require the use of a lawyer. The trustee manages the trust. They don't own anything in the trust. The trust owns the things that are in the trust. Technically, under New Mexico law, it says the trustee owns, but not the person serving as trustee, just the trustee, because they're the ones who have feet. Make sure you have a copy of the document, of course. You're going to have to read it. This is where a lawyer can help out and kind of help you through what might apply in your case. Because remember what we talked about, you only manage what's actually within that trust. There are a ton of tasks that come with managing a trust. There's the assets, the investments, the real estate, because sometimes it can be held in trust for decades. And so when you're taking on a role like this, you've got to keep in mind that you got to look for the long haul and how that's being dealt with. You have to do accountings. And so additionally, give me 1 second. I want to make sure I don't get ahead of myself. Okay. So keep in mind, you have all these myriad of tasks you have to do, and you also have much higher liability as a trustee. Because if you fail for any reason to exercise the care and skill of a prudent investor, even though you don't do this for a living, you have the right to hire somebody who can advise you and help you. It's required that you do so. So if it's an area you don't know, then you, by golly, better have somebody on board to help, because you are held to a very high standard. And the beneficiary is the worst, because they're constantly looking for a handout. One of the things that I do right off the bat, whenever there's a probate and whenever there's a trust administration, is I tell them up front, okay, this is the deal. Don't look to see anything coming your way for 6 to 9 months, because it ain't going to happen. And except for things like IRAs, designated beneficiary forms, which are treated differently, you have a death certificate, and then it ports on to the beneficiary. Otherwise, when you're working with an estate, whether it's a trust or a probate, it takes some time to kind of get the lay of the land. Sometimes there's enough money in the estate to go ahead and make a preliminary distribution, but a lot of times there's not. So that's the overview, and I told you I could get through it pretty dang quickly. And so at this point, let me go ahead and stop screen share, and I'm open for questions.
I have one. So our servicing department at American Advisors Group gave a presentation, and they highly recommend that people put their property in trusts. Is that?
There are a lot of factors that go into that. If you have difficult family situations, a second marriage, out-of-state property, then or if you have a lot of creditors, one of the ways that it's not really that you get to avoid the creditors, but it does help. So, but it's not necessarily for most people a good way to go if they just have average amount of assets, because a taxable estate right now is sitting at $11.5 million a person. And trust administration requires, for the people who created the trust, the grantors, they have to make sure that there's the care and feeding of the trust during their lifetime. And most people don't do that, which means you turn around and you have a probate and you have to administer that. I have a brand new client that just came on board. They have a lot of New York property. It came out of New York, never funded the trust. And so we're handling it here in New Mexico. And so it doesn't do any good if you don't make sure that you do all the things that you need to do. Otherwise, a trust is a pretty piece of paper, and a lot of people don't want to manage it. So I don't agree with that. And a lot of estate planners, especially here in New Mexico, because probate is not a big deal in New Mexico. You can do an informal probate. You never go to court. Everything's done, just through a series of steps, and there's not a need to go through a lot of the problems and challenges that some of the states have when it comes to probates.
Julie, many of us have clients that have businesses on top of their personal assets, which is part of their assets, but they don't take it seriously to do all the necessary paperwork to transfer that business to the next generation, or if they're going to sell it to someone. What can we as advisors do to motivate them a little better?
What, you know, that's a really interesting question. I was going through the trust, I mean, the probate code the other day. There is a whole section on being able to, it's like a transfer on death designation, just like you would do for a piece of real property or for a bank account or an IRA or whatever. And there is a way under New Mexico law to, and I mean, I've talked to several estate planners, I mean, very experienced, and they're like, really? But there is a transfer on death form within the probate statutes that you can use, that there's a whole part of an act that deals with nothing but that. So there is that's something we can talk about offline. The other thing is, it's rarely used, obviously, but if you're hoarding some shares upon your death, that's one way to do it. Another way to do it is you just put it in your estate plan that, you know, the ownership of Joe Blow LLC goes to Susie Q. So they don't have to do it through their business documents. They could make it, you know, I work with Heather Boone here in our office, and we work kind of seamlessly. So that way it's really clear, because you don't want to give any sort of, if you have one troublesome beneficiary, you want to make sure you avoid anything that would cause trouble.
And what is the
Julie,
typical
can
compensation to be in it?
beneficiary, I'm sorry, go ahead, Diane.
Go ahead.
Can a beneficiary be a fiduciary?
Yes.
Okay.
Not uncommon at all, but they have that duty of impartiality. Remember, we talked about that. And that doesn't change just because they're a beneficiary.
Yeah, okay, right.
And what percentage of total assets would you say someone should be compensated to be a fiduciary or a trustee?
We don't do it by percentage here in New Mexico. That is an option. And if that's the way they want to write it up in their documents, we can do that. It's usually on an hourly rate basis.
Okay.
Julie, I've got a quick question. So does you mentioned that to close an estate, there's a report, asset list. Does that report go to the state, or does it just go to the beneficiaries?
Goes to the heirs and or beneficiaries, depending on whether it's an intestate estate, which means there's no will, or whether it is a probated, I mean, that's also probated, or a will, and then it's a beneficiary. So it goes to the heirs and or beneficiaries to say, it kind of works like this. So we're preparing that, you know, we start from the very beginning, putting the report together, makes it easier when we get to the end. But what you do is you give it to them. They have 30 days to object. And if they don't object, and I'm not going to tell them that they can object, I just say, pursuant to New Mexico law, you're being provided this document. If we do not hear from, if I have really kind of language that lets them know that they have the right to object, but it's kind of vague. And then if they don't do anything within 30 days to object, and they have to file an objection in court, then we just go ahead and transmit them their check. So that's how we usually handle it. But that's done at the end of a probate. You have a different way, but a similar way in how you handle a trust administration.
Julie, I have a question about, you mentioned fiduciaries being far away from the person or persons at the time. What if I'm the executor of my parents' estate, but my parents live in a different state?
You know, that's why I'm dealing with kind of general stuff about fiduciaries today, because that happens a lot. I mean, you know, my parents live in Oklahoma. If I'm serving as the fiduciary, I have to follow Oklahoma law.
Okay.
However, some of the rules are pretty much the same. I mean,
Okay.
Don't be a dumbass. Use common
Right.
sense. Sure
But
that-
I would have to follow the rules in the state that they were living in.
Unless
when
for
that
some
time passed.
reason it was being administered in a different state. Let me give you an example.
Mhm.
I had one of our TANFers call me a couple of weeks ago and said, hey, I'd like for you to see if you can help with these two ladies with the trust. They have some questions, blah, blah, blah. And I said, sure. Is the trust situs in New Mexico, and do they live in New Mexico? Oh, no, this is out of Wisconsin. I said, they need a Wisconsin lawyer. Because I don't know anything about Wisconsin law, and I'm not going to practice Wisconsin law. So,
Okay, so it really just depends. They could be living in another state, but if their will or their trust is here in New Mexico, I would follow New Mexico law.
if you're having it probated here, yes.
Okay.
It depends. There are several different factors. I mean, for example, the case I just got retained on coming out of New York, in that case, they could file in New York, but the decedent moved to New Mexico about 6 months ago.
Mhm.
It's a heck of a lot easier to probate an estate in New Mexico, and there's no real estate in New York, but there's a lot of assets that are located there. So we're going to do it in New Mexico. So sometimes you have, I mean, if you have assets in different places, you have to file what's called an ancillary probate. So if I died and I had real property located in New Mexico and in Oklahoma, I would have to do an ancillary probate in Oklahoma unless I had a trust that the trust owned the property, and that's how I would avoid a second probate, because New Mexico law has nothing to do with real estate that's hanging out in Oklahoma.
So in other words, find an attorney.
That's what I said.
Julie, I have two questions. The first one being, let's say you have an individual that wants to bypass their family. They want the assets to go to someone besides their daughter, for example.
Right.
How do you handle that? How does an attorney handle that?
Well, first of all, if it's an older person, I don't meet with anybody but the person. Sometimes I have present maybe a friend or something, or sometimes they're elderly and I have to meet with one of the daughters or something like that. When I have the situation where it makes me a little uncomfortable, what I do is I make sure I have a statement from the doctor that says they have capacity, so that I have that for my file. And I schedule the signing of the documents around when they have that doctor's appointment. And then on top of it, I never have anybody in the room when we're talking about distribution, so that way we don't have that issue. So for example, Diana, if you came in with a close friend and the close friend wanted to leave everything to you and not her natural object of her bounty, which would be her daughter, then you're never going to be anywhere near any of the estate planning going on, because it makes it more apt to be challenged. And so one of the things we're looking at is, do we have good capacity? Making sure we have backup documents for that, making sure we have language in the estate planning documents, such as the will or the trust, that says, I'm not leaving any money to my daughter because during my lifetime, I supported her for her adult life and she received lots of benefits. So therefore, usually I put language in, not quite as wordy as what I just said, that outlines that I'm doing this and I have a real good reason as to why.
But you don't even have to leave them $1.
Pardon?
You don't even have to leave them $1.
No, that's a
Okay.
myth. It might be true in other
Okay.
states, not true in New
All right.
Mexico.
And the second question is timeshares. Are they treated as real property?
I have been so
all of these
lucky
come
in the
up. I'm
last 10
sorry.
years. I have not had to I deal with timeshares on my family law side. I've got a litigation case right now where we're dealing with timeshares. My off the cuff answer would be that it's not treated as real property. But I can't be for sure, because usually they own like I'm trying to think, I think it's called RCI. They own shares in RCI that give them the privilege, and they have a main place where they actually have, where they can stay for less amount of shares or whatever they have. I think the older timeshares might be treated differently and might be a problem. But for the most part, and you might also be able to deal with the timeshares through a beneficiary designation. It just depends on each timeshare. But off the top of my head, the more recent ones, they do it by points. That's what it is, points, not shares. They do it by points. And I think it's RCI, some of these big ones. And they do that so that it helps avoid problems when it comes to probate.
Anyone else?
I have a lesser question. It has to do with the medical power of attorneys.
Yeah,
Like for a while, there was a big movement with some sort, like the green form.
the most. You know,
Yeah, the most.
I had that in, I took it out. The most form, and it's confusing. So I don't ask me what it stands for because I never can remember, but I do give it to the clients, and I write at the top, supplement to healthcare power of attorney. And then I say, don't fill this out. If you have no healthcare power of attorney and you're going into the hospital, they'll have these green forms, and you can fill it out and you could use it as a healthcare power of attorney. That's what makes them confusing. On the other hand, what its real purpose is about is to be able to take that, because if you're in a legal office, you can't deal with, I don't know what the end stage of a terminal disease looks like. I mean, I have a client who has Lou Gehrig's. I have clients who have had terminal cancer of various sorts. I don't know what the end stages look like. I don't know how they want to be treated. And so, because I don't know what those things are. And so what I suggest is I give them the green form and I say, hold on to this. And if you get one of those nasty diagnoses, you sit down with your doctor and you say, what does the end stage look like so that I can write out how I want to be treated and how I'm going to, and how my agent is going to handle these situations. And so that's the ideal situation for using the most form. Thanks for bringing that up, John.
I have a question about starting the process of estate planning. I know there's lots of software options that you can go to kind of get your documents in order. When you're working with somebody new, is that kind of stuff helpful to start off with? Or would you rather just have somebody come in with nothing pre-prepared? Or what's your process, or what do you prefer in that situation?
You know, so when somebody calls me and says, I'm looking at doing my estate plan or changing it or whatever, I have to know what assets they have, because part of my job, and I feel really firmly about this. So what I do is I charge for 1 hour of my time, and it's a loss leader, but this is how it works. I charge for 1 hour of my time. I block off 3 hours for the meeting, because what I do is I go through and I do an education component where I explain what I call silos, which are beneficiary designations. Is there a trust? Is there some, this is the estate, this is how everything passes. And I explain all that in detail so that they understand it. And I use a whiteboard. You can see there's a whiteboard behind me. And I do that so that they can visualize and understand how an estate plan works. But before they come in, if they have old estate planning documents, I review those. I also look at what's called the intake sheet, and I have them fill that out. Everybody complains about the intake sheet because it takes some time to fill it out, but it's also the thing that goes in the black box, and so it's not busy work, but it also lets me know, well, so you say you have a trust. Is this funded in it? Is this funded in it? Have you put that in there? How are you wanting this asset treated? For example, when you're dealing with something like IRAs, they may say, I'm really very, I want to leave money to charity. I'm going to say, well, we're not going to do that in your estate plan, except for what I call the nuclear option, which means everybody's died and you've just got this non-human that's called a charity. So other than that, what I do is I say, as part of your estate plan umbrella, which is larger than just the estate planning documents that I've drafted, what we're going to do is take some of that IRA and we're going to port that to the charity because it goes directly to charity, doesn't pass go. And on top of it, there's no tax consequence. So let's give the after-tax money to your humans and then give the other money to charity. And so a lot of times that's the kind of planning that you're doing when you're looking at these intake sheets and you're trying to figure out how can I best help this couple or this person manage their estate so that they can manage it efficiently. And if there is a way that I can do it, that it passes outside of the estate, which is what a designated beneficiary is, if I can have it pass outside of the estate and I can keep it underneath $50,000 of net, then they don't have to file a probate. And so, so I do what I call a poor man's trust. So, so that's kind of how I manage it. And that's how I kind of, what I'm looking at when I'm looking at these assets, because as far as I'm concerned, you know, it's one thing if you have somebody who has an estate that's worth $8 or $9 million and you go, okay, if you make an error, there's money to cover it. On the other hand, if you have somebody who has a very small estate that's, you know, anywhere between 500,000, you know, because it doesn't take much to get to 500,000 because it's everything that you own, every asset that you own. And when you're looking at the assets and you're going, okay, 500,000 to say 2 million, you don't want to be spending it on attorney fees to try and figure out what did they mean and what were we supposed to do. And so it becomes even more important as far as I'm concerned to make sure that the persons that I'm talking to in this intake are well educated so they can make good decisions about how they want their estate to port to others upon their death. That was a long answer.
No, thank you. I appreciate it. I really do.
Kevin,
Oh,
Kevin Koval, you were scowling at me. Was there something that you were thinking different? Okay.
How often should trust documents be reviewed for beneficiaries and that
that's a
sort of
great
thing?
question. I have not asked Diana to give me questions. She's just doing a great job. Usually we say every 3 to 5 years or anytime you have a major change in your life. The hope with estate planning documents is that they're flexible and specific at the same time. And that's really a challenge, of course. That's what makes them longer. That's why there's a lot of stuff in them and they end up being really long. The days of the 5-page will are long gone and you still see them. But the reason that's long gone is because there's been lots and lots of litigation around those simple wills.
I've also heard you speak in the past about pre-prepared wills and how they don't maybe work in New Mexico or that they're not sufficient.
I'm going to say it real simply. You can pay a lawyer less money on the front end, or you can pay us a lot of money on the back end when you choose to use LegalZoom in some of those documents. Keep this in mind. If you write on your will after it's been executed, if you write on that will, you've invalidated it. So we had a 10-member die this was a number of years ago. And the way he dealt with it, he decided to change his estate plan. He wrote on the will. Well, it invalidated the will. You don't want that. So you want to make sure that you make your changes in accordance with New Mexico law. LegalZoom doesn't know how things work under New Mexico law. They know how things work generally under New Mexico law, but they don't know specifically. So let's say, for example, they go in, they get it witnessed because they go, yeah, I'm supposed to get it witnessed. They never get it notarized. It's out. Because it's presumed that if you wanted a valid will, you would have followed the rules. So as a result, those legal Zoom documents and all those other types of documents, I've yet to see one where it actually is meeting the goals of the client once we've discerned what their goals are. And I've had clients, I mean, who've come to me who've already done those wills, and I'm going, really? Because it's going to cost a gazillion dollars in legal fees when you die. I had one guy who actually told me, he goes, well, I haven't had any problem up to now. And I said, well, have you died? So keep that in mind, that it's, you know, if you have a relatively simple estate, you could probably do a flat fee. If you have something that has ins and outs and we really have to work on it, then it's going to cost more, but you're going to get what you pay for. So, John, you had a question.
Well, I have a case right now where the trust was done in 1991. And then SunWest Bank was the trustee of the trust and deeded it out of the trust to the mother and her two sons.
Deeded what out of the trust?
Deeded the property in
The
Albuquerque
real property?
out of the trust back in 1996. Then the mother passed away, and the other brother passed away. And so now just the one individual owns the property, but the title company is saying that they need a copy of the trust from 1991 in order to establish the legitimacy of the deed that SunWest Bank did in 1996. My client doesn't have a copy of it.
You know, there are certain ways to get copies of it. So, you know, that is a problem with the trust, because let's say a lawyer who drafted that trust has died. I don't keep originals. Those go to the client. But I, of course, have it electronically available, and we have digital files. So when you have, I mean, there's a reason why the title company is wanting it. They're wanting to make sure that they have valid chain of title. And that's a real estate issue. But on the trust side, when a trust has been, I mean, if that was the only asset in the trust is still in place. And so somewhere they have it. A lot of times what happens, I mean, one way, I have a client who has a Merrill Lynch account, and she had an old trust. She said, oh, we got rid of that trust. And I said, well, you have the termination documents that say you got rid of it? Well, no. Do you remember signing any? Well, no. And I said, well, and then she gives me information. I said, I want the face sheet of each one of your accounts. We look at the Merrill Lynch account, which has like $700,000 in it, and it's in that old trust. She doesn't have any of those documents, but Merrill Lynch will have them, because Merrill Lynch would have required that at least there be a certification of trust and part of the trust attached to it for purposes of moving forward. That's one kind of backwards way to go about getting it, is to say, well, you know, what was in that trust at the time? You might look back, they can look back, they should be able to look back and see if a certification of trust was filed at the time they filed the deed back in 1996. So, because they would have had to file, that may be why they're having difficulty, because there wasn't a certification of trust filed with the document that they filed, taking it out of the trust.
And it was done by SunWest Bank, which no longer exists.
Is their successor, whoever that is.
Bank of America?
I don't know.
Okay. All right.
And if it's Bank of America, poor soul.
Okay. Okay.
Because they've gotten rid of those documents long, long ago.
Anything else?
Thank you, Julie. That was great.
Great job. Great
Thanks.
job.
Thank you.
It's very
And-
helpful. It does raise the question, though, why would anyone ever want to take on this job?
Exactly. Yeah, I have clients who ask me, they're like, well, do you want to serve? And I went, no.
All Are there professionals that do this for a living?
There are, and they're fabulous and wonderful. I mean, we know about desert states and all of that, but there are a lot of good people out there who do great work. And I'm constantly saying, in fourth place, let's put a professional fiduciary. You go interview them, let's put them in fourth place in case they're needed. So, yeah.
Well, thank you everyone for your time this afternoon. Marissa, thank you for being a guest of Kelly's, and I'm sure she'll be talking to you about TAN. She's our liaison person.
Marissa is also going to be an education speaker later in the fall.
Oh,
Yay.
wonderful. Well, if we don't have any more questions, Julie, superior job. Thank you so much.
Yeah.
And we shall see everybody on the next TAN meeting.